Hi, my name is Oscar and I'm a scientist. Usually, we always talk about employment-based green card categories. That's the case also today, but we're going to give it a family spin. We're not going to talk about family-based green cards, but we're going to talk about what happens with your family if you get approved for an employment-based green card category, EB1A or EB2 NIW, and what happens with your relatives. Can they go with you to the US? Can they stay with you as permanent residents, or they have to find some other arrangement for themselves? We're going to cover that, and remember that here we talk about green card categories in which you can self-petition, and that means you don't have to have a job offer, company sponsoring you, and you can even do it without lawyers. Let's jump into today's topic. Very frequently asked question: what happens with my family if I get approved? I'm a person of exceptional ability or extraordinary ability. I looked at the requirements. I'm convinced I can fulfill them. I'm ready to send the petition. But what's going to happen with my family? Will they get it too? Will they get a visa? What will happen? So the short answer is your immediate relatives will obtain that lawful permanent residency or LPR status with you. And that's excellent for families. But that's the short answer. Let's go with the long one. Who is the family? Who is included? How can you do it? Okay. So what is immediate relative or immediate family? These are the members of your family that you can include: spouse, husband or wife, and children. And later we'll fine tune as to what is children for USCIS. These are members of your family that you cannot include, okay? And I get this question asked many times. Unfortunately, you cannot include grandparents, you cannot include aunts, uncles, siblings in your EB1A or EB2 NIW green card application. Okay, that's the bad news. And you get it. Everyone else in the family is also not eligible to come with you under your petition. They may be able to get a visa depending on if they study, if they work, what is their situation, but it will be a completely different application. They may also be eligible for an EB2 NIW or EB1A, but again, it will be a separate application. You cannot include them in your application, all right? So let's go with the definitions. We talked about spouse and we talked about children. So what is a spouse? A spouse is someone that you are married to, and that marriage must be valid according to the law of the place where the marriage happened. And this is called, in legal terms, place of celebration. If the marriage is legal in the country of origin where you got married, then USCIS will accept it. Same-sex marriage, this is a topic that is really relevant today, rightfully so, is getting approved in many countries, and it is accepted by the USCIS as long as it meets the criteria that I just said, that is valid in the place where that marriage took place, okay? That place of celebration rule. That also applies for same-sex marriage. Doesn't matter if it's a traditional marriage or a same-sex, you'll get accepted under the petition of the principal applicant. USCIS does not recognize the following cases, and this is a selection I took. You can go to this link that I will leave below in the description below, so you can read all those cases. But USCIS will not accept polygamous marriage, that's marriage between more than two people. Civil unions, this is important because many people may have that question. Well, I'm not married, I'm under a civil union or domestic partnership that is very common in my country. Can I be a derivative in someone's application? No. USCIS will not recognize it because it's not a marriage, okay? So you will not be accepted. You will need to get married before the process starts. Proxy marriages also not accepted when the person, at least one of the person, is not present in the marriage in the moment of the union, and relationships entered into for evading immigration laws of the U.S. And this makes absolutely a lot of sense. The USCIS will not accept your marriage if they detect that you got married just for the purpose of entering the US under someone else's application, for example. And they will inquire into this. They will, well, scrutinize your marriage during the process, okay? So as long as your marriage is valid in the country where you got married, as long as the marriage is real and it has nothing to do with the immigration process, but is a marriage that took place regardless, then you should be fine. So let's go with children, because children is a topic that is a little bit trickier. A child, by USCIS definition for permanent residency, and remember that there are other processes like naturalization for citizenship, but we are talking now about permanent residency. A child is a person under 21 years of age. But it gets a little bit more complicated because it also needs to fulfill this unmarried clause. The child cannot be married. If the son or daughter gets married, then that's no longer considered your children. It has to be biological, adopted, or stepchild relationship. So here USCIS does accept all the definitions of children, not only the biological definition, okay? And that's good news for a lot of people that may be under that situation and they are really the children of the principal applicant. They will not have issues getting that accepted. And if you want more details about the definition of children, you can go to the Immigration Nationality Act, the clause 101B1, and I'll leave a link to that. And it's a little bit legal kind of jargon. I tried to put the main things here so it's clear for everyone. Careful. Let's have a somewhat special case. Your spouse had children in a previous marriage, so your spouse will be eligible to go with you in your case. But what happens with the children from a previous marriage? They cannot be your derivatives, but they could if there is a legal stepchild relationship to you. Okay, so if you are not the stepfather legally or stepmother, those children cannot be included because they are the children of your derivative, of your spouse. But if you are the stepfather or stepmother, then they will be accepted. Let's talk about the Child Status Protection Act, or CSPA, which was enacted in 2002 and was created to protect children who turn 21 years old while waiting the adjudication of their case. This is called, in plain terms, aging out. When a child is a derivative in an application for a green card, and during the process they get older than 21 years old, they are still unmarried, but now they are not eligible. So this legislation came into effect in early 2000s to protect those children. So it applies to green card applications, including the I-140 petitions. That is what we talk about in this channel. And in summary, it allows applicants to subtract the number of days the application was pending from the child's age when the visa number becomes available by the visa bulletin. So this is a little bit tricky because this doesn't talk about the backlog of the I-485 adjustment of status. It only talks about any delay in the I-140 process. So unfortunately, for many people, this is not going to be super helpful anyway. If you want more information about CSPA, I have a link here. I'll leave it also in the description below so you can go and read at your own pace. I have now here this formula that will give you an idea of how this regulation can benefit you if you are in this situation. So what you do is you take the age at the time of the visa availability, and that's when the visa bulletin allows you to get a green card, and you can subtract the pending time, but the pending time is the pending time of the I-140. So let's say that the I-140 was pending for 1 year. You can subtract 1 year to the age of your child, and that's called the CSPA age. So if that age is less than 21 years, then they are still eligible. If that age is still beyond older than 21 years old, then they won't be eligible, okay? So what I say here is when adjustment of status backlogs are too long, CSPA may not be enough to quote unquote save your children if you file the I-140 too close to their 21 years of age. Why? Because that period of backlog, that is not what you subtract here. The pending time is the pending time for the I-140. All right, so in many cases, this will not be helpful, but in some cases, it may put you still in that children definition, and you will be able to have your children get the green card with you. Are you interested on this CSPA topic? We can make a specific video on this and bring a few examples so you can understand it better, okay? But that may be too much for today's video. So how to include your family in your green card application? There's 2 steps in this process. First, during your I-140 petition, you are the principal applicant. It's only for you. Your I-140 is just one. However, in the form, you will declare that you plan to have your derivatives come to the US with you. And I have more details on how to do this on my online course that you can join in EB2NIW.info or EB1greencard.info. They don't need to file anything on their own yet. In the I-140, it's just you declare the intention of bringing your family, but they don't have to do anything. In the second step of the process, when the I-140 petition is approved, you and your derivatives will file separate applications. So for example, if you are in the US, each person will file their adjustment of status, I-485, and you can watch the video I have on adjustment of status to understand that process better. It's going to be independent petitions. Of course, they will all refer to the principal I-140 that has been approved, but each person will have separate petitions for them. They will adjust their own status. If you are abroad, if you are applying through consular processing, each person will submit the DS-260. So essentially it's the same thing. They will have their own consular processing, even though it's all part of the same main application, and you will all go to the interview together, but each person has their own process. So you can watch the video on consular processing that I have, that I'll leave a link right here. That's it for today. If you want more information, I have these 2 websites, eb1greencard.info, eb2niw.info, or espanol.info. And what I recommend, if you're serious about this process, you join my online courses. In my online courses, I will show you everything you need to know. The requirements, how to fulfill those requirements, how to craft your petition cover letter, your reference letters, how to make your case strong and compelling for the USCIS officer. Don't hesitate to send me a question if you have doubts, but I invite you to check out that resource. It's getting stronger, it's getting more complete, and I believe really is the most comprehensive resource out there for do-it-yourself applicants. That's it from me for today. Thank you as always for subscribing, for sharing, for watching, and I'll see you in the next video. Good luck in your green card application.